And I'm a faculty member here at the Faculty of Law. I'm also the founding director of the Law, Disability and Social Change Project, and I welcome all of you. Before I introduce our distinguished guest, I first want to acknowledge the territory, the traditional territory of the Three Fires Confederacy, on which the University of Windsor sits. This confederacy comprises the Ojibwe, Ottawa, and Potawatomi peoples. I also want to provide just some logistical information so that everyone is aware of what's coming up next and comfortable during the event. I hope that everyone's had a chance to have some lunch. If not, there will be an opportunity at the end of the session. And the food is actually at the back of the room, along with tea and coffee behind us. The session itself will run for an hour and a half. And during that time, there will be the speaker's presentation as well as an opportunity for questions and answers, along with discussion. You should note that the lecture is being recorded, and the video recording will be placed on the Law, Disability and Social Change Project website shortly. I also just wanted to point out where the accessible washroom is. If you're looking for one, it's on the floor below us. There's an elevator just behind, out the door here and behind me, down to the hallway and turn right. You'll find the elevator there. So that's on the, you'll be going to the lower level. And the washroom is 2 doors away to the right from the elevator. If you need any directions at all, please don't hesitate to contact or speak with one of our Law, Disability and Social Change students, Horia over there, or even our faculty event planner, Katie Bartels, who is down the hall of the door. Okay, so the Law, Disability and Social Change Project conducts research into contemporary issues of law and disability in order to inform public policy. We're interested in overall developing more inclusive communities. It's an absolute honor for us to have the Disability Discrimination Commissioner of Australia, Alastair McEwin, join us today. Commissioner McEwin and I met as part of a research project dealing with the federal accessibility legislation in Canada. I was delighted to learn that he would be in the region in January, and absolutely thrilled that he was able to come and speak with us here at Windsor Law. After speaking with him myself on a number of occasions, I'm sure that his insights will be extremely informative and will also offer us a comparative lens for dialogue and for reflecting on how we approach disability law and realizing disability rights in Canada. So let me say a few words about Commissioner McEwin. He commenced his role in August of 2016. Commissioner McEwin's educational background is in arts, law, and business administration. Following undergraduate studies in Adelaide, Commissioner McEwin spent time in Vancouver pursuing postgraduate studies. Before moving to Sydney to work as a consultant with Accenture, a global management and IT consulting company, he worked as an associate to the Honorable Justice John Duza at the federal court. He has a strong background in working with nonprofit organizations. He's served as the executive director of Community Legal Centres in New South Wales, which is the peak body for community legal centres in New South Wales. Other roles that Alistair has held include being CEO of People with Disability Australia and manager of the Australian Centre for Disability Law. Prior to commencing his current role, Commissioner McEwin was the chairperson of the New South Wales Disability Council, which is the official advisory board to the New South Wales Government on disability issues. He was also the president of the Deaf Society of New South Wales and chairperson of the Australian Theatre of the Deaf. He's been the coordinator of the World Federation of the Deaf Expert Group on Human Rights and an adjunct lecturer for the Masters of Community Management degree at the University of Technology in Sydney. So, welcome, and we very much look forward to your remarks. I'll turn the floor over to you.
Thank you so much, Laverne, for that lovely welcome. And I just want to make sure you can all hear me. I'm speaking without a microphone, so please, at the back, let me know if you can't hear me. I can't hear myself, so it's really important that you let me know. And so, Laverne, thank you again. And I too want to acknowledge that we are meeting on the traditional territory of the Three Fires Confederacy, and I pay my respect to the traditional owners. My love affair with Canada goes back a lot when I was a small boy, and my father did a scout jamboree in the mid-1950s in Vancouver, Canada. So growing up, he talked about the wonderful experience he had coming to Vancouver and meeting with wonderful people. So I grew up with that, and I think it was almost a natural progression that I would, when offered the opportunity to spread my wings, I guess, from Adelaide, where I grew up. Adelaide is about 1.3 million people. So, you know, it was time to spread my wings. And I was offered a Rotary Ambassadorial Scholarship, so I could go anywhere. And I chose Vancouver. Well, I chose Canada because we have a lot of similarities. We have the Westminster style of government. We have the Queen as head of state, and so forth. And so my fondest memories were of the mid-90s when I was at the University of British Columbia. And now my fiancée is the chair of family and community medicine at the University of Toronto. So perfect reason to keep coming back to Canada. So thank you so much for having me. Thank you so much for putting on the Winter Wonderland. We are really enjoying it, but I'm sure for you it's an everyday occurrence. So I will be going back in a few weeks to the day before I left. It was 47.5 degrees in Sydney. So I think for me it's a welcome relief. But at the moment it's so cold here, I'm actually thinking maybe 47 degrees is not so bad. So thank you again for your hospitality, and I want to acknowledge Laverne and her team for the wonderful work that they've done to have me here. I actually want to perhaps just give you all maybe a disability discrimination in Australia 101. We are celebrating 25 years of the Disability Discrimination Act, or the DDA as we say in Australia. And unlike Canada, it's a national law specifically to make it unlawful to discriminate against people with disabilities on the basis of their disabilities. So I commend Laverne for the work that she's doing here in Canada too, and I've had a number of conversations with colleagues here about what you're trying to also do here in Canada, and I urge you to do what you can, because as many of you know, disability has a unique subset, I guess, of qualities that many people do not understand. And so every day, people with disabilities experience barriers, small, medium, large, and a lot of that is because of the lack of understanding, or perhaps even a negative attitude that people without disability have towards people with disabilities. And so my observations of Canada is there are a lot of similarities. You have some great initiatives in place, but you also have, like in Australia, what I think is a lack of strong leadership at government level that makes sure that every government department, not just the Special Disability Department or the Access Department, but making sure that everyone understands what it means to have a barrier, even a simple barrier coming to this law school this afternoon for people who perhaps use wheelchairs or people who have low vision and getting their way from A to B. But I have to say how wonderful it is to be walking around Toronto, and you are so polite. Canadians are so polite. In Australia, many people walk around obsessed at looking at their phone and not watching where they're going. And a number of my friends who are blind have had their canes broken because people are walking to them because they're not watching, they're on their phone. I think I've only seen one person since I've been here in Canada, so I commend you for being aware of how easy it is to be so absorbed in your own life and not be aware of the importance of being accessible. And I know one of my friends, the former Disability Discrimination Commissioner, had had hot coffee knocked over onto his dog because people just are not watching. So that's a simple example of how important it is to be aware of the world. Please let me know if you have any questions or comments as I go. I want to make sure you understand everything I do, and I promise to say the full title of any acronym that I tend to use, and I'm sure Laverne is also familiar with that. So the DDA, so Disability Discrimination Act, was assented, using the legal term, in November 1992. So the Disability Discrimination Act 1992, so you might be thinking, well hang on, 25 years was last year. It actually came into operation, the substantive clauses came into operation on the 1st of March 1993, and that's when it was unlawful to discriminate against people with disability. And as I said, it's a federal law, so it's standardised across Australia a one approach to discrimination. There have been, and there still are, we say states, we say provinces, so states and territories in Australia have their own anti-discrimination laws, but for the first time this is a national law designed to standardise discrimination against people with disabilities. So I love anniversaries, so I'm very excited about the 25th anniversary, and we are marking that by having an event, or one of a number of events. The signature event is on the 1st of March in Sydney, where the Australian Human Rights Commission is based. And I'll get to the Human Rights Commission in just a minute. We are marking it through having a discussion about the DDA itself. How effective has it been? So I'm going to, in a minute, tell you about some of the successes and the ways I think it has been positive, but then I'm going to talk about the challenges that still remain. And one thing that people with disability tell me is they feel the DDA is a toothless tiger, it's ineffective, and they are right to a point. So I want to explore that in a few minutes. We are also having the UN Special Rapporteur for Disability, Ms. Catalina Devander, who is responsible through the UN for monitoring disability discrimination around the world. It's an unofficial visit, and we had to call it unofficial because Australia is due to report under the Convention, and when I say the Convention, I mean the Convention on the Rights of Persons with Disability, CRPD, or DISCO, as I like to sometimes say, Disability Convention. We are being monitored, we are being scrutinised next year. However, the rapporteur really wants to meet with Australia informally, so I've taken the opportunity to use the 25th anniversary. But the government has said to me, we want to call it unofficial, otherwise if it's an official visit they have to do a whole range of reporting requirements. They are complying, but the anniversary was not quite on their radar, but I think it's important to celebrate what we can. So she's coming out to Australia as well, and I'm hoping it will be a little bit cooler by the time she comes out in March. She's based in Geneva, so I imagine a bit of snow now, but hopefully a bit cooler by the time March comes around. We also have the National Disability Strategy, and that's the Australian government's stated intent to implement in Australia, in real terms or in practical terms, the CRPD. Australia signed up to or assented to the CRPD in 2007, and then it came into force in Australia in 2008, and we were one of the first countries to do so. And we were very proactive, both the Australian government and the NGOs, or the non-government organisations in Australia, were very proactive in pushing for a convention and then being very active in the negotiation. The Australian government initially said that they didn't think there was a need for a new convention for people with disabilities. That was their official position. But due to the great work of advocacy organisations and civil society, and this is where you also play a role, the work you do in elevating the issues, talking about the issues, pushing things along despite the initial resistance. So it's a great lesson for Australia, and I'm proud of the fact that the NGOs, of which I was a part then, elevated the conversation. So we went from the Australian government saying, no, this is our position, to actually being a very proactive party to the negotiation, and including people with disabilities from Australia through things like having an NGO representative on the official delegation, supporting us at the UN in New York, and so forth. As you can see, I have a great passion for the role of NGOs, and that's where I think it's vitally important that here in Canada, which I know you do, is to keep the work you do, despite the funding from demonstrate, despite what the government may say to you from time to time, it's really important to mobilise and to work together, and in that Australia is very similar. And I promise not to make any joke or comment about your colleagues south of the border, but suffice to say the issue of the Trump administration is a hot topic, as you can imagine, for Australia as well, given our relationship with the United States. So don't worry, we're talking about Trump too, and making lots of jokes too. And I remember seeing a great video produced by a Canadian comedian talking about the wall that was being proposed to be built, and it got great traction in Australia because we get along so well with Canadians. So thank you again for your hospitality. Just very, very quickly, the DDA itself, I mean, as I said, it makes it unlawful to discriminate against a person if you have a disability. So very quickly, the definition is quite broad, and it includes the malfunction, malformation or disfigurement of a part of the person's body, or a disorder, illness or disease that affects a person's thought processes or the way they might see reality. It also includes physical, intellectual, sensory, learning and psychiatric disability. I have to say though, the convention, the CRPD, has a more broader definition, and one that puts the onus more on government and society, as opposed to saying, you're a person with a disability, you need to fit in. We should be accepting people with disabilities for who they are, and then making sure society can accommodate them. So the CRPD disability definition, there is no definition really. It basically says, what are the barriers in place that prevent somebody with a disability living a meaningful and full life? So as you can see, the trajectory has been for the DDA for the DDA itself, the definition of really a medical model, and now we've come a long way in terms of the social model of disabilities. So they're the milestones that we have in Australia. 25 years ago, the DDA, I was a very young university student at the time, and for me, the change that the DDA has brought has been quite remarkable. I commenced university and I went to the disability office and I said, I need note taking. And they said, we can't do that, you need to take the lectures and perhaps you can go home and listen to them over and over again until you understand what they're saying, or perhaps your mum can do the note taking. So that was a very old-fashioned, very antiquated paternalistic view, and that was in 1988, which was when I was a young 17, 18-year-old. So the DDA came in 1992, but by then, the lesson for me were observing what was happening elsewhere. So the University of South Australia, next door to the University of Adelaide, where I went, had an access and inclusion officer who was very proactive. She was organising sign language interpreters, note takers for my deaf friends there. So I used that as an example to say, this is a model that should be here. And also, despite not having note taking support until my final year, I didn't want anyone else to experience the same. And I think that's where I got my sense of advocacy from. And there was a young girl from my high school also starting law school, and I thought, I don't want her to have 5 years of what I've had. And I realised it called strength in numbers. So I went with her back to the University Access Office with the University of South Australia advocate and talked about it. And, we got note taking. So for the first time I was able to appreciate that sitting in classrooms is important to hear what the lecturers and students have to say. For those of you doing law, you know how the case law can be very dense and thick, and it's important to know what are the key points from your lecture and from your tutorial. My marks went up significantly in my final year, but I have to qualify that by saying I spent a lot of time in the university bar, I was in student politics, I probably could have spent a bit more time in the library, but my point remains access. Going back to how we've been travelling in Australia, the National Disability Strategy, which I mentioned earlier, is Australia's commitment, as I said, to implementing in real terms the CRPD. We've seen some success, and I'll get to that now. it's been successful in elevating the conversation, in being transparent. The government has been more transparent around its reporting and around facilitating a plan to try and achieve access and equity. It reports every couple of years against the plan. It has also implemented the National Disability Insurance Scheme, NDIS as we say in Australia, which the four letters that I hear every day. The NDIS is a person-centred approach to providing support to people with significant and permanent disability to live life as anyone else. It is a great success, in my view, of Australia implementing in very real terms Article 19 of the CRPD, which states that people have the right to live independently in the community. So what we've done in Australia is that we've gone from what was known as block funding to service providers who would get funding to then provide services to people with disability, to a model where the person with disability gets the package themselves. They sit down with a planner and they work out what do they want to achieve, or what are their goals, what do they want to achieve, and then the plan is funded on that basis. So as you can appreciate a significant shift, and I'll get to some of the challenges in a minute because I want to focus on a few more successes. The successes that I've seen in my time have also been around the Australian Human Rights Commission, is where I'm based, and I know you have the Canadian Human Rights Commission here. The model is a president and then 7 commissioners. We are all independently appointed by the Governor-General of Australia on the recommendation of Cabinet. So it's an interesting model. We sit within the Human Rights Commission and we work with the Commission staff to implement our goals and our objectives, but we are independently appointed, meaning, for example, the President can't dismiss me. Only the government of the day can dismiss me. So I have ultimate authority and responsibility for my portfolio. I have to say, though, we work wonderfully well together. We come from a wide range of backgrounds, which I think exemplifies the importance of diversity. We have a former partner of a major corporate law firm. We have a former senator, a federal senator, who's the Age Discrimination Commissioner in her early 70s. And we have younger commissioners, one who was appointed late 20s, early 30s, a philosopher, who is the Race Discrimination Commissioner, and the President herself is a highly experienced, a bureaucrat in one way. She was the former President of the Australian Law Reform Commission, so a lot of experience in analysing laws and policy. So we work together to support each other in our own goals as well as collectively. But my point now is the Human Rights Commission facilitates a complaint handling system where if a person with a disability feels that they've been discriminated against, they can make a complaint to the Commission under the DDA. For example, my local swimming pool is not accessible for me. I use a wheelchair and I can't go swimming. Our success has been to bring the parties together, noting, however, it is voluntary, so sometimes respondents don't turn up or they don't engage with the process. That's a slight weakness, but the success has been over 70% of complaints are conciliated, and a lot of people comment on the high-quality professional services that the Commission provides. I'm independent of that process. It's been recognised that for commissioners to do a really good role is to be systemic, not to do individual complaints. So 15, 20 years ago they changed the structure whereby they used to make determinations, enforceable determinations, but now a complaint-based system of which I'm independent. Having said that, I meet with the complaint team regularly to find out some of the trends and the numbers that are coming through and to see what the big issues. So there's some of the successes. We've got the National Disability Strategy, which is a really great way for the government to state that it's committed to implementation of access and equity. And we've got the NDIS, which has transformed the lives of many people with disabilities. Some who have never had the choice before of being able to say, look, my support worker is not supporting me in the way they should, I'm going to go with somebody else. And I have to say, that's challenging to service providers who have for years been used to making those decisions. So I'm delighted that the Australian government has recognised it's about what people need as opposed to what the system imposes. In the time that I have left, I want to talk briefly about some of the challenges, and of course there are many, and similar to Canada, it's about political leadership. It's also about organisations and companies, but also community, understanding, not just in a paternalistic way, but really understanding what does it mean if I can't even get out of my house today because I know it's snowing, but the accessible bus hasn't arrived, and that means I can't get to work or I can't get to my doctor's appointment. So I'm missing out on economic opportunities, or my health is at risk. So we've still got a long way to go in terms of the National Disability Strategy, and I have said this publicly many times and reported to say, I think their reporting is very lacklustre. They cherry pick things. They say, oh, New South Wales is doing a really great initiative here. Queensland up north is doing something great here. It is cherry picking, but there's no consistency and there's no detail. So I would like to see the Australian government be more coordinated as well as more thorough. So that's a challenge for me. Another challenge is employment. People with disabilities have told me again and again they want to work. They want to have the same opportunity to get into an organisation, to have career progression, to feel like they're earning away, and yes, perverse as it sounds, paying taxes, contributing to society. And so we've done a major inquiry 2 years ago at the Commission, just before I started, called Willing to Work. The Commission was asked by the government to look at the issues for older people and people with a disability in Australia. And in my view, unsurprisingly, it found that there is systemic discrimination at all levels of employment, from advertising to the recruitment to career progression to reasonable adjustment. I often am briefed by the complaint team on the types of respondents in employment matters. And on that note, 41% of matters last year were employment related under the DVA complaint. So it's a high number. The respondents are often government departments, especially federal government agencies, and I'm struck by how the issues seem to be at where it might be team leader or middle management who either are under-resourced or not resourced or have a really bad attitude towards including people with disabilities. So we can have the most fantastic CEO or the most fantastic director of the department talking about the need for inclusion, but when it trickles down to the reality, we are often seeing in employment, middle management are not responding in a positive way. Last but not least, in terms of challenges, back to the NDIS, and I dream about the NDIS because I hear about it so often, and I'm hearing so many issues around implementation. I have to say, it's 4 years old, will be 5 years old in July. Of course there are going to be implementation teething issues, of course there are going to be issues where people don't know what to do, so I'm trying to take a step back. My role, I'm not responsible for the implementation and administration of the National Disability Insurance Scheme. I do, however, have a mandate to make sure it's carried out within a human rights framework, and I am hearing breaches of human rights, for example, planners not understanding disability, or service providers withholding services unless people with disabilities pay a sum of money in advance. So you can see where there are a lot of breaches of human rights. So it's my role to make sure that the NDIS, I wanted to work, many of us want to work, but there was still a strong feeling that there are so many problems with the National Disability Insurance Scheme that we've got a long way to go. And I know in Canada there have been calls for similar programs or similar schemes, and the Every Canadian Counts, which is an organisation that's been calling for a scheme similar to Australia. Bringing this to a close, and I absolutely welcome your comments and questions. For me, perhaps being a young, idealistic, late teenager, when I went to university, I came from a background where I thought accessible, inclusive education was norm. I went to a school in Adelaide. It was a private school and had teachers of the deaf and note takers and other support all the way through. So for me, that was my environment, and I would every year, there would be all the schools around Adelaide that had deaf kids would all come together and do sport. And of course, they all had access to, some not, and some not so good, and some quite good. So I grew up thinking that was the norm. So of course, getting to university where you are literally on your own. Yes, you've got the structure of the university, but you are on your own and you have to literally advocate. So the DDA, coming in through halfway through my undergraduate period, I think for me was a milestone when I think about the tools I didn't have, what the law didn't say in 1988 when I started university. And by the way, that was the last year of free university education before the Conservative government brought in, or that the government of the day brought in fee-paying courses. So on reflection, and now that I've worked in advocacy and now that I have my current role, for me, lots to celebrate, lots to think about, lots to build on, that fundamental shift around getting everybody on the same page, from government to corporation to all of the people who are working not-for-profit, as well as universities, as well as schools, as well as employers and so forth. It's still a daily battle for many of us in terms of education, in terms of saying, look, I'm not asking you to change everything. I'm asking you to think about the barrier that can place. What can we do to move around it? So I'm absolutely delighted to be here, loving the Windsor Wonderland, and thank you so much to Laverne and to your team for having me, and I look forward to your questions and comments. Thank you.
So with that, let me open it up to any questions or comments from the audience.
Can I have a question? You spoke about the NDIS. In 2009, the commissioner for the NDIS, he said the Australian system was 90% underfunded prior to the NDIS. Now, you could make a lot of laws to protect discrimination, but how could you make a law to force the government not to discriminate against disability by cutting funding, by not supporting the disabled, basically?
Can I actually clarify, when you said in 2009, the commissioner, which commission or commissioner?
When they started, they have a commissioner, they have an inquiry, the commission for the inquiry So they said this was 90% underfunded, and I lived in Australia before the last 3 years. But you could make any laws. My question is, if you can make any laws and the fund is not there, how could you force the government to do that?
That absolutely great question, and now I understand the content of what you meant. So yes, the inquiries. So there was, I don't know what the similar equivalent here in Canada is, the Productivity Commission. So the Productivity Commission is an independent body under the Australian government that inquires into economic and social issues. And in 2010, they had the job of reviewing disability support programs across Australia. And basically, they found that the system was, I should say, underfunded and broken. So they recommended a national disability insurance scheme. The report was released in 2011, and the government brought it in 2013. You're right in that funding and the issue, one of the biggest issues, and this is an issue that the two main political parties have used to try and, well, we would say, score points off each other. And the Labor government that brought it in very quickly, and in my view, quite rightly, because we've been waiting for a long time for the scheme to be up and running. But the current Conservative government keeps claiming that it was not budgeted for and it was done in a rush. And my view is that if the previous government hadn't brought it in then, we may still not have the National Disability Insurance Scheme. Coming back to your point, how has it been funded? It's been funded primarily through, obviously, core funding, but there's also a portion of it where every Australian, or rather every Australian who pays taxes, pays a small component, a percentage of their tax to what we call the Medicare. You have, I think in Ontario, the OPIP, the Ontario Health Insurance Plan. In Australia, we have a universal federal Medicare. There's a Medicare levy that each taxpayer pays, and they've added. They started off by saying half a percent of your levy will go to the National Disability Insurance Scheme, and then last budget they increased it to 1.5%. And most Australians were very happy to do that. So they understood the importance of a funded system that can provide support and services to people with disability. But we still have that legacy of that typical when one government implements something, the opposing government will try and lose points or try and score points. So essentially, we have been assured that funding is not an issue. However, what we've seen now, the numbers of people coming in is starting to exceed what we thought might be happening. So there will be perennial issues, I suppose, around funding. But the important point is it's got to be something that becomes part of the community's way of thinking. So I'm hoping in 10 years' time, this kind of conversation will be similar to when Medicare was implemented in the mid-1970s. And if I suggested taking away Medicare, there would be, a lot of upset feelings. So I think it's important that despite funding, that we keep pushing.
I wanted to ask a question. It picks up on the funding, actually. I find that, well, first of all, I think it's very interesting, the number of barriers you've identified that are very similar to barriers that I've seen here and heard through research and interviewing. But one thing that I've noticed in doing research and speaking with various disability organizations dedicated to disability issues, is that when it comes to funding, there isn't necessarily funding dedicated to advocacy. And there's sometimes actually also barriers within the funding that's received as to whether or not it can be used for advocacy. So I was wondering, is there something similar, or is it free funding that's given in Australia?
That's another fantastic, great question, Laverne. And we've had a very interesting 5 to 6 years. So when I was working for Community Legal Centre in New South Wales, the government of the day, which is still the current government, brought in what we call the gagging clauses. So they did not want us to use our funding for what they term advocacy. And we had a lot of discussions and a lot of debate around the importance of. Their argument was, you've got to be providing services to people coming in the door. You've got to provide a service to them now. They have an immediate need, they have immediate issues, you're paid to do them. And our argument was that there's a lot of the same issues, what we call systemic issues. So there was a lot of discussion, and there were still some clauses in some government funding contracts to NGOs where they are not to use their funding. And of course, there have been a lot of pushback, and at the moment it's okay, because what we also did was we talked about, well, if we do say law reform, that's a form of advocacy, and the government said, oh, that's okay. So there was some sort of compromising, but many NGOs have a strong belief that systemic and advocacy work in terms of the bigger issues is a really important part of helping the government to understand what the issues are. And of course, in Australia, we are still seeing a lot of small organisations, very little funding, and overwhelmed with the amount of work to do. So some similar conversations here in Canada, but some very specific moves on the behalf of the government to try and silence, I guess, organisations.
You mentioned employment was one of those big areas where discrimination based on disability takes place. I was wondering if the Act mentions anything about the employer's duty to accommodate one's disability, and if it's been more to that, and also if you see some sort of a hierarchy between the accommodation of disabilities? For example, is the employer more willing to accommodate a physical disability more so than a mental disability?
Yes, so the question around employment, so the Act does specifically prohibit discrimination in employment of people with disabilities. The Act also makes it unlawful not to provide a reasonable accommodation, we say reasonable adjustment, and the law also says that the defence in not providing a reasonable adjustment is determined unjustifiable hardship, where the respondent or the person who the complaint is being made against can say it's too expensive, I don't have the funds, or it's so expensive that other things won't be able to be done in my organisation. So that's what the law says. What we've seen in practical terms is that many respondents use that defence quite effectively to worry about the floodgate or to get really down into details about a person with a disability is too expensive and it's not worth it. So that's one of the big challenges. In terms of your question around the sort of the hierarchy, the differences, a lot of people, like employers, think, oh, we should build a ramp into our building and that's it. They don't think about their website, it's inaccessible. They don't think about career progression for someone who is deaf and, say, not providing interpreters for professional development opportunities. They don't think about making their information accessible. So we've still got a long way to go. We see a lot of people talk about the ramp, which is important, but of course there are still problems with getting accessible buildings in Australia. We've made some progress, but essentially a lot of people still have that image of what they can see as opposed to what they can't see.
Professor Gillay.
Thank you for that wonderful talk. Just to follow up on the question that was just asked, you mentioned that there's not always an understanding of the day-to-day experience of barriers. And in the context of employment in Australia, is there also a emergence of understanding around caregivers? So, for example, an individual who's caring for a disabled parent or child. And if so, how does that factor in? And my understanding, Laverne would know more, but my understanding is in Ontario, we have guidelines around caregivers, but I'm very curious as to what that would be in Australia.
Yes, so thank you for your question. In Australia, we take carers. So we have, for example, the National Carers Alliance, and they are a fundamental part of the way we see disability in Australia. And using the NDIS as an example, we've worked very hard to develop guidelines that ensure that ultimately the person with a disability is the final, the ultimate decision maker, that the care that they have is provided in a way that protects, for example, with the employment conditions of carers, as well as flexibility to work with the person with a disability, because we recognise that it's all part of, talking like being part of a team. And so in Australia, we've had a lot of conversation, particularly in the last 4 years or 5 years, as the NDIS was developing, is to make sure that carers are an essential part and that they have the condition and environment in which to be able to be their best. One of the problems, though, is that there aren't enough. We're not seeing enough carers who are qualified to work with people with disabilities, and there's so many people coming onto the NDIS, the workforce is not ready. So that's something that the government has been working hard on. They have, for example, a national carers and disability support group within the government, and they've set up the National Disability and Carers Advisory Council. So there are mechanisms to make sure that carers are part of the conversation.
I probably didn't frame my question specifically enough. That's very helpful. What if in a family situation you have one adult and one disabled individual? So the one adult sometimes can't get out of the house because the disabled individual can't get out of the house. Does accommodation extend to that person?
Yeah. Thank you for clarifying that. that's a good example. So what we've also been discussing is lots of families have been caring for their child or adult or sibling with a disability and so forth. We haven't quite been able to work out. There's a lot of discussion around formal and informal support. And how do you quantify informal support, such as the example you gave of in the home or in the family? That is quite rightly a big conversation, and because the NDIS is set up to be person-centred, we still haven't quite resolved the issue of family support and how that works. Should they be paid, or should we recognise informal support as part of the package? How does that all work? So it is actually a work in progress, and it's been driven by the NDIS, and I firmly believe it's a conversation that we need to keep having, because when we also think about so many of our friends without disability, it's part of their life to just work or support their friends with disabilities in everyday life, but should they be, that shouldn't be really part of a formal system. That's a great question, and we are working on it.
I saw a question in the back.
Thank you, Paul. What tools do you have to answer the all too frequent reasonable accommodation barrier, which is not quite a good answer to a request?
So it's the reasonable accommodation barrier. What tools?
Yeah, what tools do you have to answer the too frequent? It's a bit too frequent, but the reasonable accommodation is brought forward as a no. We can't accommodate this request because it's not reasonable, and I don't think it's an answer. But what tools do you have?
Thank you. Do you mean, for example, an employer or perhaps a school or a service provider?
Service provider, employer.
The billion-dollar question, I think. So, starting with the law simply says an employer or somebody must provide reasonable adjustment. It doesn't define reasonable adjustment. And I don't believe it should be defined, because once you start listing something, people will use that as an excuse to say, well, it's not in there, we're not going to provide it. That's the law. What we've tried to do at the Commission and on our website, and this is a bit of a plug for what's on our website, we have lots of resources for example, women coming back from maternity leave, from having children. How can you make sure that they can return to work in a way that is supportive? And so for disability, what we've done is we've got a range of resources. The most recent one is a resource, or rather a good practice guide that came out of the Willing to Work inquiry. So there's a massive report, 300 pages plus, and then there's a short practical guide. And one of the biggest challenges, and sort of to answer your question, is I was trying to encourage schools and education providers and employees, be creative. Don't just merely, it's not always about deducing the law. The law says you must, but be creative. And a lot of the requirements of reasonable accommodations that come through the complaint are about, I have a mental health issue, it's just been diagnosed, I'd like to take 1 day off a week or 1 day at home. And a lot of employees still haven't quite grappled with that. So there are some tools, but I think ultimately it's about being creative. It's about companies starting to recognise the value of keeping employees no matter what their ability. So to bring my answer back to your question is, the tools that we have on our website, there are also a lot of organisations who have developed some great toolkits. So, for example, with the Australian Network on Disability works with employees to actually get them to understand reasonable adjustment. I still think part of the problem is that there isn't one-stop place where people can go. But sadly to say, many employees still use the unjustifiable hardship, which I think is one of the bones of my existence is that terminology. I mean, it's a double negative, unjust and hard. So people with disabilities are hard to deal with, and it's unjust for me as a person without a disability. So in summary, there are lots of tools out there in Australia, but ultimately the law doesn't define quite rightly reasonable adjustment.
Ms. Whitmore.
We're seeing with our provincial government in Ontario some expansion in a pretty solid way in direct funding options for both adults and for parents for their children as well too. It's something that as service providers, and I work with the Children's Treatment Center, we're looking at what do we need to provide to parents in our case to assist them to be able to manage some of the, there are the benefits to direct funding options, but there's also some challenges and responsibilities that families will take on with that. Did you find a way of educating and supporting families and also individuals themselves through this process?
That's another wonderful question, and one of my big priority areas. I've got 6 priority areas, and one of them is education. And supporting, I believe it's about supporting both the family, but also teachers to be more innovative, perhaps, or to think more creatively about accommodating students with disabilities. What we often find with the complaints that come to the Commission under Education is the relationship between the families and, for example, the school is quite toxic because the family might have a very fixed view of what they want for their child, and they're saying, we know what's best. But what I've observed, often when they're given other solutions, it doesn't quite look like what they think it should be. So I think an important role for me is to try and get families to understand, okay, here's the goal, but there's lots of different ways of getting there. So in Australia we have that quite in a big way, because I understand, particularly for my parents as an example, they had a particular path that they wanted me to go on, and sometimes perhaps I didn't have sign language growing up at that school. Would that have been better for me? Who knows? So yeah, in Australia we have a big challenge, particularly through the complaint system, where sadly a lot of the relationship is broken down between the family and the education setting, and that makes it much harder to try and conciliate. So coming back to the NDIS, what the NDIS has been working very hard on is supporting families to be better equipped, to have more options for them, to have funding not just for respite but for independent living skills for their child. And I had a great story of, I ran a a consultation on Human Rights Day in Melbourne, and a mother arrived with her young son who had Down syndrome, and she wanted to stay with the son in the consultation, and I said, no, this is about young people talking. So we still see parents, and naturally for all of us who are parents, it's hard to let go, but at the same time I've seen so many families hold back their child with a disability. So I think there's a lot of commonality, and the key is to get the funding right from an early stage. And so the NDIA, or the NDIA rather, the agency that's tasked with the implementation, is working specifically on early intervention.
Thank you very much, Commissioner, for being with us today. My question is this. You mentioned quite rightly that there are many similarities between the Australian and Canadian systems, but one difference, of course, is that Canada has a Charter of Rights and Australia does not. I'm wondering, from a practical perspective, from a disability rights activist perspective, does that make a difference on the ground?
Absolutely, I think absolutely. And if I had another hour, I could talk to you about my views about why it's so important to have. I know still in Canada you still have many challenges around enforcing and interpreting, I suppose, the Charter of Rights. But we need this because it's important to be able to have I like the one-stop phase. And for us, in trying to, when we have the Disability Discrimination Act, we have the Australian Human Rights Commission Act, which includes functions under human rights and incorporates some of the international treaties. Then we have state and territory anti-discrimination laws, and some of them are very different. For example, we don't have a national vilification law. We don't have a national vilification law. We have a state and territory anti-discrimination laws, and some of them are very different. For example, we don't have a national vilification law. We have a state and territory anti-discrimination laws, and some of them are very different. For example, we don't have a national vilification law. 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 whereas New South Wales does have, it's against the law to vilify someone for their disability. So that's an example of where it would be great if every Australian could have a single charter. So we did try. In 2010, we had the government said, okay, we'll open up for consultations, and there were many consultations, and we all participated. And then they decided, no, we're not going to progress. Having said that, Victoria, so Melbourne, which is the capital of Victoria, and the ACT, the Australian Capital Territory, Canberra, our nation's capital, they both have charters. And I've seen, particularly in Victoria, a lot of great casework law that comes through by enforcing. So, yeah, my dream is that we will have it. At the moment, there's no current appetite at federal level, but the conversations we have on it at the Human Rights Commission and with our colleagues every day.
Are there any other questions or comments? Yeah.
Just had a question about, in terms of programs for education, talking a little bit from my own experiences, oftentimes these programs to help people in education who have disabilities are done separately. Like, for example, independent education program. I find that sometimes these can actually be isolating, and so I was wondering if you could speak a little bit about perhaps if there is a possibility of programs that are more integrated rather than isolated.
Thank you. And look, I don't believe that every child, every adult should be able to get educated in circumstances like this, where everyone is together as part of the community. You're asking me about what we have as segregated schooling and, and mainstream. So yeah, the big issue in Australia. And firstly, the law. Again, I'll quickly go back to the law. Obviously, discrimination against somebody on the basis of their disability in education is not allowed. We also have, and I should have mentioned this earlier, we have 3 standards under the Disability Discrimination Act, and these standards are also legally enforceable, and they are standards for accessible premises, accessible transport, and education. And they really they clarify the obligation under the law, but they're enforceable as well. So in Australia, we still have a very strong view that children with disabilities should be educated separately. And my view, however, is that under the Convention on the Rights of Persons with Disabilities, everyone has the right to an educational setting that best meets their needs. And the research shows children with disabilities who are educated in mainstream and regular schools do better than both socially and academically than children with disabilities who are educated isolated, as you say. So I would love to see more movement. There is a growing movement in Australia. There's an organisation called All Means All. And it was set up by a group of parents who strongly believe that being able to send your child to the local primary school is the right to every child. So it's a big conversation. I'm hoping by the end of my term that I have gotten the government to understand better. They're actually still funding special schools. In some ways, they're even increasing the funding to the special, sorry, I'll use the term special schools, but my views on the particular terminology, they're still increasing. So that means to me we still have a long way to go. And I think if I'd gone to a school that was segregated, I often wonder what would my social skills have been like? What would my ability have been like to communicate? Yes, I had lots of problems. I couldn't follow what was going on all the time, and I know there was comments made behind my back, but at least I was socialising, and I was doing things like school camps, and I was doing things like swimming. So yes, for me, education probably worked out as one of my biggest passions, because I've seen how the commitment of teachers, and I have to say, I caught up on Saturday night on my way here in London with my old teacher of the deaf from grade 8. She and her husband came out to Australia, and she secretly told me I was her favourite student, but I'm not sure whether she said that to everyone. But she adapted. She was the first person at my school to start using signage. and she would sign the assembly. And I'd never had that before. So she was very progressive, and she gave me the skills to think about other ways of communication. So I'm absolutely committed to, I know it's a tough job for teaching. I know you've got 30 children running around, or all different, but we're all different. And I just think we need to see that from that angle, rather than, oh, you have a disability. We are still also saying, and I'll wrap up my answer, is as a parent, to go to the principals of local schools and say, I don't want my child with that particular child. So still a very negative attitude. Going back to my comment, also principals are not handling the situation well, so by the time the complaint comes to the commission, the relationship is very toxic. So anyway, that's my dream, and I think it's absolutely achievable.
Thank you. Not seeing any further questions, I want to thank you so much for joining us today and for your lecture, and very insightful both lecture and discussion. I think that what I really appreciated about your comments was the ability that you have to illustrate things so clearly. I think they've really made things quite vivid for us in terms of thinking through connections between our law and Australia's law, and different circumstances here and those in Australia. So thank you. I will invite everyone to continue these conversations. So we have a little bit of time left in the room. Please, I'm sure that Commissioner McEwin would love to have you chat with him. And I hope to see everyone this evening as well at 5 o'clock. So thank you very much.
Well, thank you. Thank you again so much for having me, and I want to acknowledge again Laverne and her team for their fantastic support, and also to Kira for very patiently taking the notes and for clearly understanding my accent. So clearly my accent hasn't been too much of an issue, so well done Kira, and thank you again for all your questions and comments, and also particularly for your commitment to advocacy in disability discrimination. So thank you.